We'll start with an issue that's top of mind, no doubt, for everyone around the table. In a few weeks, comments are due for a cost-benefit analysis that the SEC is conducting on a potential uniform fiduciary duty rule. This rule has been considered for a number of years, and now we're to the cost-benefit analysis stage. David, we'll start with you. IAA and 8 other groups sent a letter to SEC Chairman Mary Jo White last week expressing concern about the parameters of a potential uniform standard that were included in the cost-benefit analysis. And your letter said, referring to the parameters, this approach would have negative consequences for investors and is one we would vigorously oppose. Could you elaborate on what your concerns are at this stage about the direction that the uniform fiduciary standard is going?
Absolutely. Fiduciary duty, I thought that was settled years ago. Now this thing has been going on. I think I signed our first comment letter on the SEC's fiduciary rule back in 2000. So this debate has been raging for well over a decade. And our organization has certainly been involved. We recently joined with our friends at the Financial Planning Coalition and the state securities regulators, some consumer organizations, to write the letter to Chair White that you referred to, Mark. And by the way, for people who read these joint letters, trying to get 7, 8, 9 groups together, you might just read it and think, oh, you know, those groups, they're always walking in lockstep. It took a lot of effort to get that page-and-a-half letter put together, but the question has always been, what should the standard of care be for people who are giving investment advice to their clients? And so our organization and like-minded organizations have for years said that it is appropriate for the highest standard of care, the fiduciary duty, to attach when people are giving investment advice. And Congress has certainly gotten into the act. There is a provision in Dodd-Frank, Section 913, which I'm sure everybody here is very familiar with and will talk about, but there is a potential for a rulemaking on that subject. The SEC on March 1st published this request for information. It goes to a lot of cost benefit and other issues. We'll certainly respond to that letter, as will all the people around this table, I'm sure. But we believe that, again, that the Advisors Act fiduciary duty, which has been in place for decades, certainly confirmed by the United States Supreme Court in a decision in 1963. It's been consistently interpreted by courts and the SEC. That is the fiduciary duty that should attach.
And your groups are saying if that's not the fiduciary duty that attaches, it's better not to do anything. Is that right? And how important is that statement? I mean, you guys have been working on this for years, and now you're saying, forget about it.
Yeah, I don't think it's anything new from my perspective, right. But I'll let others certainly talk about it. But I think that the fiduciary duty, the well-established fiduciary duty, if the SEC were to water that down considerably, yeah, it'd be better if they did not do that. So that's one of the points of the joint letter. It's certainly a point that we've said for a long time. Don't water down this duty that has been very well established, and don't create different standards of care for different types of clients. When we get into the details of 913, it's providing personalized investment advice to retail clients, are the operative terms in the statute. But the SEC has authority to extend that to other types of clients as well.
And Ira, let me turn to you. Throughout the cost-benefit analysis request, the SEC says repeatedly, we may not follow these parameters when we draft a rule. But nonetheless, one of the parameters states this: The uniform fiduciary standard of conduct would apply within the context of the scope of services agreed to between the customer and the broker-dealer or investment advisor, and would not generally require the broker-dealer or investment advisor to provide services beyond those agreed to through a contractual or other arrangement or understanding with the retail client. That sounds a lot like the fiduciary framework that SIFMA submitted in July of 2011 to the SEC. What do you think about the request for information and the parameters?
Well, Mark, look, I think first you have to go back to the basic premise of the request. And the SEC bent over backwards to remind everybody that they haven't made up their minds. This is a list of 70 pages worth of questions, and they want feedback from everybody, the folks around this table, as well as other commenters. And if people have other ideas or suggestions, they're inviting that as well. I think at SIFMA, where we kind of start, the first principle here is the what. You know, you heard David talk about the what. Well, for us, the what is having a fiduciary standard of care when personalized investment advice about securities is being delivered to the retail investing public. Now, that's a long sentence and it's a mouthful, and every term needs to be discussed and defined and so forth. But for 4 years now, David was talking about comment letters going on for years and years. It was 4 years ago that SIFMA publicly embraced a uniform fiduciary standard of care for retail clients. So I think we're agreeing with the what of fiduciary standard, and what I think we all need to spend a lot of time talking about is the how it should be implemented. You heard some reference to the Investment Advisors Act fiduciary standard, well-established, Supreme Court case from 1963. Look, the act has been on the books for almost 74 years. I think what we're suggesting is a fresh look by the SEC as the expert agency in securities matters to take the best of the existing Advisors Act, a best interest of the customer, a duty of care, a duty of loyalty, taking those principles and putting them hardwired into a regulation that would apply equally to the Advisors Act side and to the broker-dealer regulatory side. And I think everyone should have the comfort that within Dodd-Frank itself, the actual law, it prevents any watering down. No one's looking for Fiduciary Lite or any sort of minimal fiduciary standard. But what we are looking for is clear guidance so that as we all move forward, whether you're on the investment advisor side or the broker-dealer side, and just as a quick footnote, the SIFMA membership has both. Our members are both registered investment advisors, registered broker-dealers. So we have all different shapes and sizes and business models. So what we're looking for is for the SEC to move forward, and credit should be given to them for taking us to this next part of the process, the cost-benefit analysis, and SIFMA, like the groups assembled, will be responding.
But SIFMA must be pleased that one part of the backboard that's being used to respond against is an idea, like I said, that sounds a lot like your fiduciary framework, right?
I don't take pleasure or a whole degree of comfort because I think, as I said at the outset, that the SEC is trying to be, very transparent and indicate a whole list of different ways forward, and they're looking for comment and feedback.
Marilyn, why don't you chime in here?
Well, I was really happy to hear Iris say best interest of the client, because we are also signatories on the letter, and one of the, if you actually put in place a fiduciary standard that is consistent with the assumptions that were outlined in the SEC's request for information, a key concept of the fiduciary standard is missing from those assumptions, and that is the best interest of the client. Other assumptions seem to lead to a disclosure-only type of fiduciary standard, and in our view, a disclosure-only fiduciary standard is not a fiduciary standard. It has to be based in the rock-bottom principle of the best interest of the client. So we really felt it was important to signal to the SEC that the assumptions that the SEC very carefully laid out in that 70-page document, if put into a rule, would not be what we think is a true fiduciary standard of conduct.
But and Dale, let's get you into this. Even Barney Frank, though, before he left Congress, wrote to then chair of the SEC, Mary Shapiro, saying that the Dodd-Frank Act did not give the SEC license to lay the 40 Act over brokers. Correct. So, what do you think about the direction that this issue is going?
Well, before I just had a couple of kind of thoughts, a couple of points that inform our view on this issue. FSI members are independent broker-dealers and the independent advisors that they license, and as such, similar to SIFMA members, our members operate under both the broker-dealer and investment advisor rules, and have therefore significant and growing component of their business operates fully and successfully under the existing fiduciary standard. The second thing that informs our view is we think that we should all continue to look for ways to expand access to affordable and quality advice for everyone. Now, the wealthier among us will always have choices and options. It's the smaller investor who far too often faces the potential of getting priced out of the reach of affordable and competent advice. So our view is similar to what Ira has articulated. We think what would be best for investors in the industry is a new uniform fiduciary standard that encompasses the principles of putting the best interest of the client first, making sure that the client's fully informed through appropriate disclosure, and that all conflicts of interest are managed successfully, so that the client has options, gets good advice, it is afforded the protections that come from a fiduciary standard. Yeah, I think to your question, Mark, I think Mr. Frank made it expressed, while nobody else signed his letter, I think it was pretty clear that the intent of Congress with the language they chose and negotiated to insert in that section of the Dodd-Frank Act was to give the SEC the latitude to study and explore the options, but then to kind of put some guardrails around so that they wouldn't simply come and impose the 40 Act standard on broker-dealer activity. Right. Our bottom line is looking to avoid those unintended consequences of giving advice to the small investor.
So can I just ask the last question to you, David? There have been concerns raised about linking harmonization with the fiduciary rule, and should those two issues be linked together, or are they separate issues?
I think they're totally separate issues, and for my money, I'd just soon see harmonization go completely away, Fred. But certainly some people, some groups have linked them. There are provisions, questions in this request for information that is outstanding by the SEC that allude to harmonization issues. If you're going to deal with harmonization, which to me is a code word for taking the broker-dealer rule book and imposing it on investment advisors, not the other way around. That's how anybody that has used harmonization seems to use that particular term. For a number of reasons, we think that's completely wrong-headed. There's no good information or evidence that requires that sort of analysis. Look, investment advisors are comprehensively regulated right now, and that's part of what's been missing, in my judgment, from the harmonization debate, is a recognition of how investment advisors are already regulated. They're subject to all sorts of rules and regulations, as well as the overarching fiduciary duty. So I'm no fan of harmonization, in case you didn't pick that up.
I guess not.
Could I jump in here
Sure.
just real quick? I think that, what I'm listening to, I think we're all kind of saying the same thing. I think all of us agree that the fiduciary standard that should be applicable to broker-dealers is no less stringent than that applicable to IAs, which is act in the best interest of your clients. However, as Ira was saying, it's the context that makes the difference. And it gets back to the point you just made about harmonization. The reason harmonization doesn't work is because the contextual application of the fiduciary duty to broker-dealers is different than the application of that duty to IAs, even though the duty itself could be exactly the same. And if I understood what Ira said what we should be focusing on is how should it be implemented? You know, can there be clear guidance? Well, you know, I think that worrying about the context, I don't know that the SEC is ever going to be in a position to anticipate every factual scenario, every possible scenario that could occur at a broker-dealer firm and be able to draft a rule on the front end that applies to every possible scenario. And I don't think that's the way the law works. We go as far as we can, we anticipate broad issues, and then as the tricky, hairy issues come up, we do what we can with them. But in dealing with the question on disclosure, you know, one of the things we've talked about is allowances under the broker-dealer model. And I think by definition, whenever you have if we have a fiduciary standard that's applicable to broker-dealers, and then you start talking about allowances, you've just required a discussion about heightened disclosure. Because at some point, if there are allowances, the broker-dealer is going to be sitting there in front of their client, and the fiduciary standard is going to apply, and all of a sudden it's not. Then it's going to apply, then it's not. Well, we've just created a disclosure issue that also has to be considered whenever we consider rulemaking surrounding the fiduciary duty.
Right.